Good morning, everybody. Name's Dylan Greenwood, managing partner here at Greenwood Law, here with
Harold Eustache. I'm an attorney here at Greenwood Law.
And this is For the Record with Greenwood Law, and today we're going to start a two-part series on DWIs. If you follow us closely, you know that we've already discussed kind of the overview of what a DWI charge is, all the elements, and going through each and then every individual one of those to figure out if somebody is guilty or innocent of that crime, of that accusation. Before you ever get to that point, though, there are a number of factors that play into whether or not you even look at those elements in the first place. And those things are reasonable suspicion and probable cause. And you probably heard those at some point. They're pretty common terms within the legal system and in the justice system. But with reasonable suspicion, that's what we're going to focus in on today. And Harold, how exactly does reasonable suspicion play into a DWI?
Well, reasonable suspicion is really the first thing that an officer or law enforcement officer has to deal with when they're stopping a person. So generally, in the context of a DWI, a person is driving along on the road, and everybody's been driving, and an officer spots a person and would have some reasonable suspicion that a crime is afoot, essentially, and they have to have what's called articulable facts, or something that they can actually talk about or say as to what that person is doing that constitutes a violation of what we call Chapter 20. And Chapter 20 is a part of the North Carolina General Statute that governs all traffic violations in North Carolina. And so an officer would have to see either some Chapter 20 violation or some other crime being committed to stop that person. It's a Fourth Amendment issue as to whether somebody can be stopped.
Right. So the reason why this is important with a DWI, or really anything involving a traffic stop or walking on the side of the road or whatever, there's got to be a reason for the interaction you have with that police officer, or any law enforcement officer for that reason. So if there was no reason for this law enforcement officer, to stop you and to initiate that contact, then the stop itself would be illegal based off of the Constitution of the United States and the Constitution of North Carolina. And so the reason why we look at these issues is because if that occurs, and it is an illegal stop, then every piece of evidence that is gathered subject to that illegal stop cannot come into a court. And so it's called a motion to suppress. And basically you're suppressing all the evidence that could have been gathered after that stop occurred.
And that's like the classic fruit of the poisonous tree thing from law school, where everything, whatever happens right then, everything else is poisoned after that illegal stop, essentially.
Right, you're exactly right. And so, as you could see, it really applies directly to DWIs, because from a lawyer's perspective, the first thing that you look at is, why in the world did you get stopped in the first place? What was going on? So the way an attorney looks at this, and the standard that they apply for reasonable articulable suspicion, it's whether there are objective and articulable facts about an individual that, when taken together with rational inferences from those facts, warrant intrusion. And you have to look at the totality of the circumstances and figure out, all the different factors that could be involved. And that there's a number of ways in which a person can be pulled over based off of that standard.
Right. And one of the important things to remember is, when it comes to that standard, it is a lower standard as far as our bars in criminal justice, but it can't just be a hunch by the officer. It can't just be, I think that some sort of crime is happening, but they don't have actual articulable facts to say, and reasonable inferences from those facts to say that a crime actually happened. And that's important because there's a lot of case law around whether an officer can follow somebody for a long time, or and stop them based on knowing that person. I mean, there's a lot of interactions in communities sometimes where an officer may recognize somebody that he has stopped before.
But it has to be specific to that time.
It has to be specific to that time. That's right.
It can't be because of some other, purely on some other prior interaction. Now, it doesn't mean that a prior interaction can't come about, especially if there are facts to support some stuff. But it is a certain standard that has to be met. It is a very low bar, especially when you compare it to the standard to find somebody guilty, which is beyond a reasonable doubt. And so this is way, way, way down the line as to what it can be. And there are a number of ways in which somebody can be stopped pursuant to a DWI. So one is that you're stopped based off of the suspicion that a DWI is occurring. That's not the only way, though. The only way, and the other way, and probably the most common way, is that some other traffic violation has occurred for that stop to be initiated by a law enforcement officer. But there's kind of a unique prong in the law where just because you get stopped, it doesn't automatically mean that you're going to be investigated for DWI. There was a case that came out that said if you're stopped for some other traffic violation, a law enforcement officer has to develop separate reasonable suspicion that a DWI is occurring to prolong the stop beyond what would have reasonably occurred based off of the type of traffic law that someone was pulled over for.
Sure. So if you're driving along and an officer suspects that you're speeding and pulls you over for that, and just a regular speeding ticket, the officer can't without new facts for DWI can't prolong that stop to see maybe there is a DWI, or bring another officer in without any new sort of facts to support that. So that's really important.
Right, and a way in which a law enforcement officer might be able to prolong would be, let's say someone gets pulled over, they roll down their window, and the car reeks of alcohol. That's one thing. Now, that in and of itself doesn't necessarily mean that some criminal activity is afoot. There's a chance that maybe you went to the ABC store and you're putting the bottle of whatever you bought into your car, and it busted open, and now all of a sudden it saturated your car and it just reeks. That's a perfectly reasonable explanation for what occurred. But again, an officer is looking for the totality of all the circumstances. So all of a sudden, if they're smelling something, they're talking to you and you sound like this and your speech is all slurred, then that's going to be a big factor, a big key. And then they're going to also look at what your eyes look like, because most people, when they drink, get this kind of red, glassy look to their eyes.
So Dylan, a lot of times when people think about somebody getting stopped for DWI, they think of the person that's kind of all over the road. Can you, if there is that person all over the road, can you explain, does an officer have the ability to pull somebody over for just kind of weaving? Is that a crime, and how does that work?
So just a few instances of weaving is not enough. In North Carolina, we're what's called a weave plus doctrine state. And so that weaving either usually has to be coupled with some other bad driving. Not all the time. I mean, if the weaving occurs over a substantial length, or whether that be in miles or in time, then that could be enough to get someone over the hump to be pulled over for DWI. But typically, it has to be combined with some other factor. And so, multiple times crossing the yellow line, speeding up suddenly, slowing down suddenly, not reacting to certain things that happen in the course of the driving in a manner in which you might expect. Factors in which maybe you weren't driving with your lights on when you should have been, or having your high beams on when you shouldn't have been.
Mm-hmm.
Those are all things that add up together to potentially be that plus in the weave plus doctrine issue. It's not just about driving, though. It could even come down to where you were coming from. So if an officer saw you come from an establishment that is known for serving alcohol, specifically a bar, and then you get in your car and you start driving, that could be enough for reasonable suspicion. And in fact, when I was in college, a buddy of mine, that's what happened. He was walking from a bar. The cop watched him the whole time, watched him get in the car, cranked it up, started to pull out of the parking lot, blue lights. And, he wasn't able to get too far. And, that held up in a court.
Mm-hmm.
So it is a pretty low bar to meet. There are a number of different things. There's about 30 plus in total that can be combined with weaving that would cause an officer to pull someone over. And recently, courts in North Carolina have further interpreted that weaving erratically to amount as weave plus as well. So it isn't just one occurrence of crossing the line. A court or a law enforcement officer doesn't expect you to drive perfectly. Even when perfectly sober, how many of us drive perfectly out on the road the whole time?
Nobody. Right.
No, if not, personal injury lawyers wouldn't have any business, right?
Mm-hmm.
But it is something where if you're doing it really erratically, if the driver weaves violently and quickly within their lane, then that could be a sufficient hump to get over that weave plus doctrine. The plus being how erratic it was, how violent it was, that sort of thing. So that's what is really looked at if someone is going to be pulled over specifically for suspicion of a DWI.
Right, and a lot of times in court, this, a lot of the challenges that happen, as Dylan alluded to earlier about motions to suppress, when we do have suppression motions on reasonable suspicion, a lot of times they are surrounding this weave plus doctrine, because certain Chapter 20 offenses like expired registration or driving while license revoked, there's not the same subjectivity there for an officer. So for these kind of weave plus doctrines, a lot of times we're standing in court if we're doing a suppression motion. We're looking at a dash cam, the camera footage of what happened on the road, and really parsing it out frame by frame. Did this person cross the yellow line? Did they cross the fog line? How many times? Over how much distance? And all that stuff is adding up to making this sort of argument that whether or not this officer had reasonable suspicion to pull over.
And probably the more trained and seasoned law enforcement officers. So think specifically a lot of times state troopers who are key in on this type of behavior, have a lot of really specialized training in it. A lot of times they can spot a potential DWI based off of really subtle movements.
Oh, yeah.
And then follow that car to actually get what a court would recognize as a reasonable suspicion. That happens quite a bit. And they see what they think, and until you give them an opportunity to get pulled over, and then that's what they execute.
Mm-hmm.
But let's say you get to a point where you're being pulled over. Blue lights happen. Harold, what's the first thing you should do, or what should your demeanor be with that police officer?
You should certainly be compliant with the officer. I mean, take any commands as far as, stopping your vehicle in a reasonable amount of time. But you should be inquiring as to why you were stopped, and getting an understanding of that.
And you have that right.
Yeah.
You have that right to ask that. Why was I stopped? Obviously, in North Carolina, every driver out on the road is subject to provide a license.
Right.
So they're going to ask you for your license. They're going to ask you for your registration. You need to hand that over. There's nothing wrong with handing that over. But sometimes officers, when they pull someone over, they either would like to immediately try to search or ask you to immediately search your car, depending upon what happens. Do officers necessarily have that right, Harold?
No, they don't, unless there's some sort of, they would have to, we can get into this later a little bit more, but they would have to have probable cause to search your vehicle. But probable cause can be trumped essentially by, an admission, or not an admission, but someone consent to search. And if someone gives consent to search, then all that other stuff goes out of the window. And so a lot of times a lot of our clients and people that we come in contact with think that if an officer asks to search, that they have to do it. And that just simply isn't true.
Not at all.
People don't have to allow an officer to search just because they ask.
Right. If you're just joining us here on WTOB, this is Dylan Greenwood and Harold Eustache, and we're in the middle of a two-part series on DWIs. In this first part, we're talking about all the ways in which somebody could be stopped for suspicion of a DWI, or if stopped for another reason, how the traffic stop could be extended, and then that person would then be investigated for a potential DWI. And that's all based off of a standard called reasonable suspicion. And reasonable suspicion is basically a legal standard that was created based off of Fourth Amendment law to determine whether or not a law enforcement officer could have an interaction with you and initiate some sort of investigation, basically. And when they're pulling you over, Harold, that's exactly what they're doing.
Mm-hmm.
They're initiating an investigation. So you need to assume from the moment they start talking to you, really even before that, but especially when they start talking to you, they are taking in any and every piece of evidence, and it's not necessarily in your favor. And that's any time you get stopped.
Right.
They've got a job to do. They've been trained to do their job in that way, and that's how it's occurring. But Harold, not every DWI interaction or every interaction with a law enforcement officer is due to kind of that stereotypical what everybody would think of. They're driving along the side of the road, see the lights in the rearview mirror, heart starts beating quick, and then they pull over and have that interaction with the officer. It happens in other ways too.
It does. One of the other ways that it happens, particularly in DWIs, are checkpoints and checking stations. And there's a lot of law surrounding checkpoints because there isn't, for the driver on the road, that driver there hasn't been some individual, reasonable, articulable suspicion about that individual driver in order for them to be stopped, but they are stopped by a checking station. So there's lots of various standards that have to be met by law enforcement in order for a checking station to be valid. One of the things is that in North Carolina, it used to be that there would be a DWI checking station and just a regular traffic checking station. And now in North Carolina, there's only one type of checking station, and that is for any Chapter 20 offense. And what that means is that the checking station is looking for any traffic violation, be it an expired registration or any other traffic violation. And again, at that stop for the checking station, if there is independent and subsequent, information that an officer gathers that leads to a DWI investigation, that would happen after that initial contact. But in that checking station, there's some important things. First of all, there needs to be a plan by law enforcement, needs to be written. That plan needs to be shared among law enforcement agencies if it's joint. Also, there needs to be, it can't be just stopping vehicles because of the way they look or randomly. There needs to be an actual sort of policy to stopping vehicles, be it every vehicle, every second vehicle, every third. I mean, and it has to stay the same throughout that entire checkpoint. There also has to be a purpose for that checkpoint, and the purpose for that checkpoint has to have some sort of rhyme or reason to it, and has to be explained by whatever officer is in charge of that checkpoint. And all those things have to be proven if challenged at a hearing, at a suppression hearing. So these type of checkpoints can be suppressed in court. It is common for them to be suppressed in court, and because there's a different standard for these checkpoints, it is a little different than just the normal stop, because there's a lot more on law enforcement to show in order for them to overcome the hurdle that they are able to intrude on a driver via the Fourth Amendment. So that's one way, and there's another way where sometimes people officers encounter people, for other reasons.
Yeah,
too.
Voluntarily or through safety checks.
Mm-hmm.
Those are ways. The easiest way to think about that, we talked before in a prior segment about, the person that goes out to an establishment, they have some drinks, they think they're doing the right thing
Mm-hmm.
by sleeping in their car and not getting out on the road.
Right.
And then they get cold or they get hot, they turn on their car, and that's operating the vehicle. Well, they're guilty of a DWI if found that way. A lot of times the being found in that way by the officer comes down to a safety check. They are an officer, a law enforcement officer, is justified if they see a car that's parked like that to investigate, to make sure that someone is okay or whatever else in that way. Another way in which that could happen is through a traffic accident. If there's a traffic accident that has occurred, obviously that has some implications for a Chapter 20 violation too,
Mm-hmm.
because maybe it's a failure to yield or exceeding a safe speed or whatever else that might have led to the accident. But even regardless of that, just the duty of an officer as a first responder to check for the safety and well-being of the people involved in that accident, they have a duty to respond and a duty to initiate that interaction. And so from then on, they're going to start talking to you, and they can do that on the scene of the accident, they can do that at the hospital, they can do that at a number of places, and talk to you and potentially develop enough reasonable suspicion to continue on with an investigation that you potentially were driving while impaired. And so, that's another way. Once all of this stuff happens, and let's say you're pulled or you're having that interaction with the officer, then an officer, again, every step they take with you is a form of trying to gather evidence. And so from then on out, a lot of times officers are going to ask you to do field sobriety tests, submit to breath sensors, all that sort of thing. And that's all stuff that we're going to touch on in the second part of this series,
Mm-hmm.
because that's a very important aspect of all of this. That is how potentially you are arrested and taken down to a station or the jail or the magistrate's office and subjected to either a breath and toxicolizer machine or a blood test. So there's a lot of stuff that plays into all that. And, when it gets down to it on reasonable suspicion, just because you get pulled over doesn't mean that the officer got it right. That's where we come into play. That's where any attorney comes into play on this. Now, that being said, in the moment, you may believe that it wasn't right, and after the fact, it may in fact not be right. But in that moment, we definitely recommend that you be compliant, be courteous with that officer. They're trying to do a job. If it's at night or whatever else, they may be they may be just as scared as you are because they don't know what they're walking into. So we just always remind everybody out there just to remember to be courteous.
Thank you all for joining us for the Record with Greenwood Law. Don't forget to join us next week where we are going to be talking about our second part of this DWI special, where we're going to be talking about probable cause. We're going to go through each and every standardized field sobriety test and even some of the unstandardized field sobriety tests that officers use in order to determine whether or not to arrest somebody in a DWI. So it'd be really interesting.
Yeah, but before we go, do not forget the Greenwood Law Bill of Rights. And that's first and foremost, I will not represent myself in court. Just don't do it. Second, I will not do law enforcement's job for them. Third, I will not make statements when stopped by law enforcement. Now, it's okay to give that license. It's okay to give that registration. But you don't have to start telling everything that you ever did. Number 4, I will not consent to searches when asked by law enforcement. And 5, I will not be my own star witness for the prosecution. Remember, everyone, it's not a crime to know your rights. And it's definitely not a crime to assert those rights. But as always, be safe, be courteous. Other people are doing their jobs too. Stay informed, stay safe. This is For the Record with Greenwood Law, signing off.